First of all, we are undergoing AV upgrades in Courtroom 19A, which is why we're scheduled today for 7A, so I apologize for any confusion that might have been called about the courtrooms that we're in, and I hope everybody's here. If you need somebody present who's not here, just let me know. I haven't made this announcement before, but let me make it today, and we'll talk about it in depth a little bit later. Unless you're a member of the media, and the media has badges that display that they are members of the media, then you cannot pull an electronic device out in this courtroom and use it, particularly if you're behind the bar or the railing that separates the well of the courtroom from the spectator area of the courtroom. So that's a rule that applies in all of the courtrooms here. And if someone displays their cell phone or other electronic device, you're going to be told to stop by the court deputies or remove from the courtroom. And that is a security precaution that we take in all courtrooms in all cases, and so I want to advise you of that and so that you're aware of that situation. We're going to talk later today or Monday about spectators who are wearing shirts pertaining to people involved in this case in one way or another, and that's a conversation we're going to have a little later. I haven't imposed any prohibition on that up to this point in time, but once we get to pre-trial going forward, I am going to impose that restriction so everybody knows. We are on the record in 2016 CF 15738, CF 17826, with the attorneys announce their appearances on the records this morning. Thank you.
Brad King and Rick Ridgway from the state of Florida.
Roger Weed is standby counsel at this point, Mr. Loyd.
Candace Holland, standby counsel.
All right, thanks. And for the record, Mr. Loyd's present. Well, Mr. Loyd, at our last meeting, you filed a motion for the appointment of counsel, and we had some preliminary conversations about that, and honestly, I was happy to hear that you want to be represented by counsel. And I made some statements at that time about considering your matter and being maybe inclined to grant it. And I want to talk to you about that matter today. I want you to be represented by an attorney, Mr. Loyd. This, as I've repeatedly said in this case, the issues in this case, they're important, they're complex. It's true in all criminal cases, but it's especially true in this case. And navigating the procedure and the case law and the rules of court and the complex practice of law, and that's difficult, Mr. Loyd, for anyone and any pro-defendant. It's as true for you as it is for anyone in your position, maybe even more so for you. So it's tempting for me just to appoint counsel from outside this area to ensure that you have counsel. And I've carefully considered your request, but I'm unable to grant your request for Mr. Lenneman to be your lawyer for a few reasons, and I want to list those reasons. First, the case law is clear that an indigent defendant has the right to competent counsel but does not have the right to choose a particular court-appointed counsel. And I've read numerous cases, and I have them with me this morning, that hold that. So you don't legally possess the right to pick and choose a lawyer who will represent you if the state is paying for that lawyer. Second, neither I nor any judge that I'm aware of in this circuit has ever permitted an indigent defendant to insist on a particular attorney, even an attorney, let me just finish, even one who's local, much less someone from another county. So I would be making really a special and an unheard of exemption just for you, Mr. Loyd. Attorneys locally have agreed to be on a court-appointed counsel list, sometimes referred to as the wheel, and it's unfair to them to just skip them and go to a distant county to provide counsel for you. Third, I've appointed competent local standby counsel for you, and even though you don't get to choose your attorney, if you want to be represented by counsel, it is likely that I would appoint Mr. Whedon and Ms. Hawthorne to represent you as co-chairs in this case. And fourth, Mr. Loyd, there's a procedure known as a Nelson hearing whereby you can ask me to discharge counsel who is not providing competent representation to you. And this isn't to suggest in any way that Mr. Whedon or Ms. Hawthorne wouldn't provide you competent representation, but there is a procedure, a safeguard, where you can bring to the attention of the court that you feel that court-appointed counsel, whoever that might be, is not competent to represent you. And Mr. Loyd, I strongly encourage you to have legal counsel, but unless you're paying for that attorney, you don't just get to choose who the lawyer is, and I'm not inclined, even though I know that his reputation is stellar, I'm not inclined to appoint a Dade County attorney to represent you in this Orange County case for the reasons that I have stated, and so I'm denying your motion to appoint Mr. Lenneman. But I will appoint an attorney to represent you from this wheel. And
I want to renew my objection, which I don't know if you filed it, because I haven't seen it, I haven't got a copy of it. Well, I filed on the objection for standby counsel, and for the counsel hearing, I filed my objection in my written form for the counsel hearing, which you said last time you got in court, you said on record. That you said you got it, but I don't know if you even filed it.
I checked Odyssey.
I know you ain't filed it, but I got another motion that I got to come. I want you to excuse yourself off my objection because you've been compromised.
Have a seat, Mr. Loyd. So, a couple of things. I checked Odyssey this morning. I haven't seen any of those filings.
You said in court, and I gave last time we was in court, not this time, but last thing on the 27th, I asked that you get it, and you put on record that you got it, and it was noted, but you didn't file it because now you doing stuff to try to compromise me.
All right, I'll check the record again to see if I'm in possession of it.
You ain't filed it. I sent it in, you said you got it in court.
I'll check, but I checked Odyssey this morning and I didn't see these.
I got a copy of it.
All right. I want to take this point by point, Mr. Loyd. So the issue is this. Unless Mr. Lenneman wants to represent you pro bono, and I wouldn't ask an attorney to do that. I mean, it's a choice for him, but that is asking a lot. And then I'm not going to appoint Mr. Lenneman to be your attorney. Mr. Whedon?
Your Honor, I'd like to bring to your attention the Rule of Criminal Procedure 3.112, which I believe gives the lead counsel the authority to request the particular appointment of second chair in a case. And Mr. Lenneman indicated to me this morning that he'd be willing to take the case in that respect. This is going to be a very difficult case. It will require a lot of work. I would talk to Ms. Hawthorne about that. She has no objection to standing down and allow me to serve that rule in terms of allow me as lead to choose second chair of the case. And since he's the JAC approved attorney that practices throughout the state, I think that would really help facilitate the case.
I'm really not familiar with that application of that rule. So do you have any case that supports what you're arguing?
I prefer
All right, and what rule did you cite again?
3.112.
What subsection of the rule?
Your Honor, I wasn't prepared to address those issues today, so I need a moment to pull it up. E.
All right, give me a sec. Well, there is a sentence in the rule that says lead counsel shall have the right to select co-counsel from attorneys on the lead counsel or co-counsel list. So doesn't that refer to the list that's kept in this county? Do you have the rule there?
I understand your position, Judge. And Ms. Hawthorne is willing to step aside, and I think that this would really help this case go forward much more smoothly, Your Honor. He does. Because we have this residency requirement, he can't be on this list apparently, but he's on the list in other counties around the state, so he's obviously well qualified and recognized in other jurisdictions to receive appointments, and he's has the JAC contract, and I think ask the court to allow me to choose him as the second chair based on that rule and based on Ms. Hawthorne's willingness to step aside.
I have no question Mr. Lenneman's on a list somewhere, maybe multiple county lists, maybe Dade and Broward County, I'm not sure, but he's not on our list. And what I'm asking is, does this language refer to the list that we keep here, which is a list that Ms. Hawthorne is on? And so that's why I'm asking, I mean, you are familiar with the rule. Is there any case that indicates that the list refers to a statewide list, or is it a local list that applies for appointment of counsel? I've always understood it to be the local list, but if I'm wrong, let me know.
I wasn't anticipating being in this position today, Judge.
Okay.
I thought based on our conversations that we might be going forward with Mr. Lindeman, so I'm not.
Okay. Do you need a little time to do that research? Because we're going to meet again Monday, at least at this point we are.
I have the Rosario trial set on Monday with Judge Marquez. It's the devil of the case that speedy trial is running on.
Okay. Mr. Loyd, do you want to talk to Mr. Whedon or even Mr. Lenneman about my ruling to see where you're going from here and whether you need any more time? Because the next matter that we're going to move to is Monday's pretrial conference for the trial of this case. And I want to talk to you about whether you're ready to go to trial on May 1st. Do you want to talk to the two attorneys about your current situation or not? I'm going to take a brief recess. I'm going to let you discuss what I've ruled on with them. Then we're going to come out, we're going to talk about the status of the trial, that is the pretrial conference that's scheduled for Monday, and the trial period that currently is set for May 1st. So I'll take a 10-minute recess and then we'll be back out. I mean, he can check it if he wants, but I'm okay.
rise. Roll come to order.
All right, have a seat. All right, we still have a lot of work to do yet, but Mr. Loyd, can you tell me where we are on this issue of counsel, and whether you want me to appoint Mr. Whedon to be your counsel? Yes.
We spoke, and that we told him about the situation we're facing here. He has authorized me to request recess in this case until Monday, so I can research these issues about the rule. It seems to give the court-appointed attorney authority to choose second counsel, second chair. Mr. Lindemoon has applied previously in the past to be on the list here in this circuit.
Hold off over there. Go ahead.
There's a residency issue that was waived for Ms. Hawthorne, but apparently was not waived for him. And there are 6-minute issues also, constitutional issues in this rule, so I need a chance to research those matters.
Well, one thing that's obvious right now is you're not lead counsel, because Mr. Loyd doesn't have counsel. I mean, where we are right now is your standby counsel. And the rule, it seems to me, discusses actual appointed counsel. And so that's one observation. And then the other one is, if Mr. Loyd were to accept you as lead counsel, then the rule permits you to file a motion with the court about the need for a co-chair or co-counsel. And that would give you time and the state time to take, I don't know if the state really cares about this, but you time to research the rule. I've expressed my concerns, so I would want you to address those concerns. In reading it over the break, it seems to me to refer to the local list, but as you said, you didn't have time to research because you didn't think it was going to come up, so you would have time to research it. But there's a clock that's ticking away, and I want to know whether we're preparing for trial in May, and I've got a number of other issues to deal with.
We expected today to file a motion continuous, Judge, and to waive speedy trial, believing that myself and Mr. Lindemoon would be appointed counsel to represent him, and we had discussions about that with Mr. Loyd, and we were prepared to waive speedy trial and start preparing the case. If you want to recess until tomorrow morning, we could.
Well, hang on to that issue, because there's another issue that I want to address. I have a number of issues today. We may or may not get through all of them. What I have received from Mr. Loyd and what the clerk has is his motion for discovery, and that's filed in Odyssey with the clerk, a pleading in opposition to the psychological evaluation that I requested Dr. Danziger do, and his formal objection to the appointment of counsel, and that is filed with the clerk of the court. The motion to appoint Mr. Lindemoon as his counsel, and then a brief one-paragraph letter that's entitled, "Excuse me, sir, I would also like to have a copy of the motion that was filed in my case not to seek the death penalty and any and every other thing that was filed in my case, thank you," that was also filed with the clerk of the court. So I have those. What I don't have is a motion to disqualify the court. And do you have a copy of that? Did you draft that? All right, so you haven't filed that motion with the court. And do you want to file a motion to disqualify? Is that what you said earlier?
I got a fear, I fear that I won't receive a fair trial or fair hearing in this court.
Well, we're in a very particular procedural posture if you indicate to the court that you want the court disqualified, which requires you to file a written motion. And I want to know if you intend to file it, or you need time to file it, or where we are. And Mr. Whedon, if you want to help out, if you've been authorized to.
I'm still standby counsel, and so I'd be available to talk to Mr. Loyd about all those issues, and I'd be glad to speak with him about those. I don't know if Your Honor has time tomorrow to review matters, or...
You know, I'm bringing Mr. King up. I would recess till this afternoon if there's going to be a motion to disqualify, that I could review, and because there are a number of issues I'd still like to get to today. But my understanding of the case law is if a motion is filed, whether it's even procedurally correct or not, if a motion is filed, then I need to stop and rule on that motion before we go forward on other matters. And I'm happy to do that, but I don't have that motion. And if the motion is just being thought of, then there's other issues we can address today and keep working. If Mr. Loyd tells me he wants to file that motion as the next step in this process, then I'm going to stop and give him some time to do so, and I'll review it and I'll rule on it. I think we're all pretty familiar with the case law in that area.
I don't think he would do that without further consultation with counsel.
So do you want me to keep working today, Mr. Loyd, and then you're going to talk to someone about whether you want to move to disqualify me or not?
Yeah, I already talked.
Do you want to keep going?
I want to get rescheduled so we can get other stuff done. We didn't know all this was going to happen.
Well, I didn't know all this was going to happen either, because there are some issues that I'm hearing without written motions that I'm unaware of, but I have a list of things to work through. But if you're telling me that you want me to stop because you want me to disqualify myself, I'm going to stop, even if it's just for a matter of minutes or hours, so that you can file that motion and I can review it, because that's my understanding of what the case law requires. And so I need some clarification from you about whether you want me to disqualify myself now, or you're thinking about that and you want to keep working, or... Pardon me?
I'm thinking about it.
Do you want me to continue going through the matters that we have scheduled for today? I want to talk about Dr. Dansinger. I want to talk about pleadings that the state of Florida has filed with you, and I want to talk about next Monday.
Your Honor, I think
I want to address the attorney issue first.
Well, okay, I do too. So I'm happy to talk about the attorney issue. And I just want to be clear about this. If you want appointed counsel, I am likely to appoint Mr. Whedon. At that point in time, Mr. Whedon can file whatever motion he thinks is appropriate about co-counsel. I may or may not appoint Mr. Lenneman. I don't know yet. I have some concerns about whether I should appoint him. But Mr. Whedon cited to me a rule without any case law accompanying it. He said he needs a little time to research it, and I would review whether or not Mr. Lenneman would be appointed as co-chair. He may not. He may. I don't know. I haven't decided that yet. And it's not. If you accept Mr. Whedon as your attorney, it's not conditioned on, well, I get Mr. Lenneman at the same time, because I might grant that or I might deny that. I want to be absolutely clear about that. But if you want counsel, and I think you need counsel, and I've said every time I want you to have counsel, and you want Mr. Whedon, I'm going to appoint him, and then I'll go from there.
Your Honor indicated also a reference to the Nelson hearing that at some point Mr. Loyd had grounds to discharge me as an attorney. We'd have a hearing on that, but at least that would allow me time to file the proper motions to address Mr. Lenneman. He's indicated to me, Judge, that this is a concern, that travel costs, accommodations, and all would not be billed.
Okay, and you know, that is something I would like for you to put forth in the motion so it's clear and I understand with some particularity what it is that you're proposing, and so that I can consider that in ruling on the motion. So I appreciate that, but sometimes we're getting a little ahead of ourselves. The issue is, Mr. Loyd, do you want me to appoint counsel for you? That would be Mr. Whedon, and he can file whatever he wants. Sure. All right, Mr. Whedon.
Your Honor, Mr. Lloyd has agreed, he confirmed that he'll allow me to be appointed as his counsel. Not standby, but as his counsel, he's agreed to waive speedy trial and prepared 2 motions here. I assume the state has every objection to continuance, right?
Your Honor, if the defendant's waiving speedy trial, and I think maybe being over technical, but it'd be nice to have the defendant on the record saying that, and if that's the case, then we would have no objection.
Okay. Mr. Lloyd, is it your desire that I appoint Mr. Whedon to be your court-appointed counsel in this case, in both cases? I may or may not appoint Mr. Lenneman as co-chair. I haven't decided that yet. So it's not conditioned on that. In other words, it's not, I'll only take him if you do that. I'll rule on that when it's presented to me. So do you want me to appoint Mr. Whedon to represent you? All right. So I'll make that appointment at this time. Mr. Whedon has asked the court to continue the case, which is considering that the state has filed a notice of intention to seek death in both of these cases, is on a very short track right now. Mr. Whedon, on your behalf, is moving to continue the case, I'm sure, so that discovery can be done and research can be done, which would result in a waiver of speedy trial, which means the state is not then required to bring you to trial within 175 days of your arrest. Now, this is a right that Mr. Whedon will explain to you. You can demand back later in time if you ever want to do that. But if I grant your motion to continue, it would waive speedy trial. Do you understand that? Is that what you want me to do? All right, then I will grant your motion to continue and I'll waive speedy trial. There are some things I just want to announce, Mr. Lloyd, while you're here, so that I'm certain that you know about these things. One, as you know, Dr. Danziger came out to see you. You had earlier expressed to me that you did not want him to examine you. When he came to see you, you would not speak to him. He filed a 2-page report with the court. I'm going to order that it be filed under seal, since it deals with, and not much depth, but it does deal with mental health issues. I have a copy. If the state doesn't have it, I have a copy for the state. I have a copy for you, Mr. Whedon, and I'm going to give you a copy for Mr. Lloyd. Mr. Lloyd, the other thing I want to advise you of, and Mr. Whedon will talk to you in detail about this. The state of Florida has filed a notice of its intention to seek death in both cases. In CF 2016-15738, the state has listed in its notice of intention to seek death 5 aggravating factors that it intends to prove at trial. It has also filed a notice of its intention to admit similar fact evidence. We're going to give you that in 1 second. We'll give you that in 1 second, sir, because I want you to focus on this for just a minute, and then we'll give you that report. The state has filed what's called a Williams Rule notice. Now Mr. Whedon can explain that to you. If you didn't have counsel, I was going to tell you that they filed this notice of intention to use similar fact evidence against you. In 2017-826, the state has filed its notice of intent to seek death as a penalty and has listed 8 aggravating factors that it intends to prove in seeking that, and has also filed this Williams Rule notice. They have also filed a motion for DNA samples. I'm prepared to rule on that today, but since you've just been appointed, if you need a little time, I'll give you a little time. Mr. Whedon, I don't know if you have a position on that yet or not.
I need to discuss that with Mr. Lloyd.
Okay. Those are pretty pro forma, but I'll give you the opportunity to talk to him about that. Mr. Whedon, the other matter you may or may not be aware of, and Mr. Lloyd, you may or may not be aware of, is the state previously filed a motion to restrict disclosure of certain discovery matters, and in particular, a video that purportedly shows the alleged murder of a police officer. I want you to be aware of that. That's on file. I'll give you some time now to review that. The motion to continue has obviated my concerns about my next statement, which is it appeared to me that no witnesses have been deposed up to this point in time, and that was of a concern to the court, but your appointment, I think, alleviates that concern. One thing we should talk about is, I don't know if it's necessary that we have a pre-trial conference on Monday, but since we have the time scheduled, we could call up the certain motions. We could call up the motion for DNA, we can call up the motion to restrict the disclosure of certain discovery material, and I can entertain any motions that you intend to file between now and Monday. So we can make Monday motions hearing and not necessarily pre-trial for a May 1st trial. Oh, you have that trial?
Yes, it is.
Oh, okay. And is that trial pretty certain?
Very certain. Judge Marquez has reserved the 23rd floor, and she's got a large pool of jurors coming in, so.
Okay.
That is correct, Your Honor, but just so that the court's aware, I filed a motion to continue that trial because
Okay.
we have not gotten any witness list or expert list for penalty phase. And so
Is this a guilt phase, penalty phase trial, or a resentencing?
it's a guilt and penalty phase.
Okay. And you're handling that case, Mr. King?
I'm part of
Part of it, okay.
Yes, sir.
All right, well, one thing we could do is this. Is that motion scheduled for hearing?
At 11 o'clock.
Why don't we do this? Why don't I keep the time just on my calendar for Monday? If that matter gets continued, we can meet and discuss this case. If it doesn't and you're in trial, then we'll just continue the Monday hearing. In other words, we keep it on the book until you know your schedule. That way we can at least start to address some of these motions that
I
have
would
been...
tell you, though, I do have another trial with Judge Craner, State versus Kelty set for Monday as well. So if Rosario gets continued, then most likely I'll be in trial in Mr. Kelty's case.
I'll tell you what, I'm not going to cancel it yet on my calendar, but I will accommodate your trial conflicts. And what I propose is this: if your calendar opens up, since everybody right now is scheduled to be here Monday in this courthouse, what courtroom is unclear, if your time opens up, then we'll just meet here. And if it does not, in light of the continuance, the pressure is off, and then we can schedule these motions, but I want to kind of get to work on those matters.
When you say here, Your Honor, do you mean in 7A again? Or we can find that out
Well,
later?
I have 19A next week, right? Just this week. Yeah, it would really be 19A.
19A.
19A, I'd like to get back to that. 19D, I apologize, 19D. Should know my own courtroom. All right, anything else for today that's...
Yes.
I'm sorry.
Go ahead.
If we have the hearings on Monday, would the court intend to take up the Williams Rule notice motion then, or would you want that
I
separate?
think I'd give the defense a little time on that. That one, you would want more time, I presume. Yeah. These would be the motions for DNA, the motion to restrict discovery, and then if you file a motion about co-chair, I would like to address that at that time. All right? Okay. Yes, Mr.
The
King.
other thing I have, Your Honor, is I have the discovery in the 2017, I think it's 816 case in electronic format. It does include the video and the autopsy photographs that I was going to supply to counsel. I can either do that with the court's instruction that they not divulge those two items to anyone else, or I can wait until Monday, whichever counsel prefers.
Well, I can certainly inform the court that I will not do anything with those until it reads.
All right, I appreciate that. So Mr. King will give you the matters, but you won't divulge those two issues addressed in his motions till I rule. Thank you.
Your Honor, just for the record, I'm tendering a thumb drive that Ms. Hawthorne had given me and a written list of witnesses to Mr. Williams.
Ms. Hawthorne wanted me to inquire also, Judge, so at this point, is she standby second chair?
No? Really, in light of your directing me to the rule, I don't know that I have co-chair for you yet. And although I have not handled a death penalty case where I have an appointed co-chair, so I think you're going to have co-chair. And the issue is whether it will be Ms. Hawthorne or Mr. Lenneman. Some of the issues you started to touch upon, costs associated with someone at such a distance, I presume you're going to talk to me about that. Maybe both of us will I might check with JAC just about whether they have any positions. Do you have any objection to that? And you might probably will be doing the same thing.
I I don't anticipate any objections because he does handle cases in Marion County, County.
I just want to, there, sometimes the Justice Administration Commission has rules that I am unaware of because I don't know all of their rules. So I might call them just to say, review with me, are there any restrictions or regulations that you have about a situation like this? And I thought you probably would too, just so that I can address them. And so then we'll go from there. Folks, beginning next week, I would ask that you not appear in court wearing a T-shirt that either represents Mr. Lloyd's picture or the pictures of either of the victims. And I've been patient with that up to now, but that raises some concerns about security and ultimately, as we move towards trial, about tainting participants in the trial. And so I'm going to ask that practice end now. And I realize there are emotions attached to both sides of this case about the people involved in the case, but I'm going to ask you to not wear T-shirts that depict images or statements of people from this point forward. All right. Thank you, everybody, for today's participation. We'll be in recess. Mr. Lloyd gets that, and yes. Yeah. We'll do it.